we leave discipline? Behavior. There are two cases, paragraph C on page 31. That's a brand new case from Colorado called the Ebony S. versus Pueblo case. And this was a case regarding a child with who's in kindergarten who was multiply disabled. She was born to a mom addicted to cocaine. So she had multiple disabilities, including an intellectual disability and numerous physical ailments. When she was in class, she was placed in a desk. Let me go back. She was placed in a desk where the court described the desk as basically, there was a special desk that were U-shaped, that the student is surrounded on three sides by the desk, and a rubber bar goes over so the student cannot just push her chair out and get out. The student could get out of the restraint, although the parents testified that due to the student's limited physical abilities due to her disability, she would not be able to slide or crawl out of the desk. The school said they only used it a few minutes at a time. The parents said, no, I observed it longer than that. The school was sued for a constitutional deprivation of rights of the student. And I wish I had more time, but I'm going to whet your appetite. And this case is in your materials, again, on page 31, paragraph C. And it just came out at the end of August, so it's relatively new. In this case, they said, first, it is undisputed that the desk did restrict the student's movement. The position that it forced her to assume, seated in a chair facing forward, is the standard pose required of countless school children across the nation. Significantly, the restrictions imposed on Ebony did not remove her from the classroom environment. The controversial portion of the desk was its restraining bar, but there is no evidence that the bar would force a student to sit in any unusual manner. Second, Ebony had the ability to remove herself from the restraints imposed on her. However, we must assume on the facts most favorable to the parent, because some of these cases, and I explained this, some of these cases are like on what's called a motion for summary judgment. So since most of you are non-attorneys, when the court rules on a motion, we have to assume that what the allegations are true for our analysis. So this wasn't necessarily a separate fact-finding process by the court. We have to assume, as the parents allege, she was unable to lift a bar if it was latched in place due to her physical ailments. But there is no testimony that she could not get out of the desk by crawling over or sliding under the front portion. Thus, the record indicates that Ebony was only inhibited from getting out of the desk in one manner, by pushing her chair back. Finally, we find significant that the straining mechanisms were not attached to the student's body. This fact distinguishes circumstances from other cases that the parents cited. The parents argue that the opportunities for motion is irrelevant in light of the fact that Ebony was indisputably not allowed to leave her desk. But a teacher's command that a student remain sitting upright in her seat is an example of a restriction of movement that is inherent in everyday compulsory school attendance. The court found no violation of her constitutional rights. I'm not here, by the way, to promote seclusion or restraint. And I did want to just point out, without getting into all the details, that you have a fairly detailed set of regulations in your administrative code that on aversives and behavioral plans that, among other things, say that the IEP team has to look at the use of 2 positive behavioral interventions and attempts, and when those failed, before even considering aversives such as restraint or certain kinds of seclusion. and of course cannot be used as punishment. It would be part of the behavioral plan would be part of the IEP, and of course parent would have to consent to that IEP. So that there are all these caveats. The Clark case that is on the bottom of page 32, case from Missouri. Here was a 9-year-old who is other health impaired, attention deficit disorder, seizure disorder, and, quote, autistic-like. The student had a history of some challenging behaviors. The student had a behavioral component to their IEP. The student's IEP's behavioral component called for various levels of intervention, including the use of a support room and a secure observation room when necessary to address the student's extreme or dangerous behavior. The support room is a regular-sized class where a student can go to take a break to refocus, complete work in a quiet area. In the support room were a beanbag chair, a weighted blanket with a pad, a teacher's desk, a couple of students' desks, a video monitor, a sink, and a storage area. There's an observation window through which someone can observe from an adjoining room. The secure observation room had padded walls and a floor. They're lighted. They have an air vent and windows in the door. Each is equipped with a video camera, permitting the student to be observed at all times. Each is also equipped with a magnetic locking door. On the wall immediately outside of the door is a button which operates the door. In order to engage the magnetic lock, the door must be completely closed and the button pushed. The lock works only so long as the button remains pushed. As soon as the button is released, the door unlocks and disengages. The door can be locked and remain locked only if someone is within arm's length of the door with their hand on the button. The parent vehemently opposed the consideration and use of these rooms as part of a comprehensive intervention plan. Ultimately, the court upheld their use. Two things. First of all, the overwhelming evidence is that the student was subjected to continuing observations and evaluations by his teachers. Numerous strategies and interventions designed with specific positive behavioral goals were implemented continuously. The overwhelming evidence shows that there was not indiscriminate use of these rooms, but rather they were used as a last resort after all other strategies had failed. And further, by the end of the year, was drastically decreased. First of all, they kept data. November, it was used 29 times. April, once. Reports to parents on every time it was used. There is no evidence that the student's behavioral problems were not sufficiently controlled by a change in the student's placement and prohibited from receiving a FAPE. In other words, the court said these were used as a last resort. But I am not putting my rubber stamp of endorsement. I'm suggesting that this case is getting lots of attention. First of all, part of a comprehensive evaluation, other less intensive or intrusive interventions were attempted and used and documented. But the data showed, first of all, this was, quote, as a last resort when the student was about to imminently hurt themselves, and that the data showed throughout the year there was a decreasing to almost not using it at all by the end of the year. I happen to think that was very important for the court to show the improvement in the child's behavior. And the parent was vehemently opposed, but did acknowledge that they were kept in the information loop, that this was not done behind their back after they objected, that they did get a report every time it was used. If you look at your aversives and your behavioral plan, similarly, The parent consent, parent must be notified within 24 hours after certain interventions are used. It's part of an IEP. By the way, if it's not working, consider changing it. And this makes me crazy. The intervention of, okay, this child's out of control, so we'll send her home for the rest of the day. And then she comes back the next day, and she's sent home because she wants to go home. There was a case years ago out of New Hampshire. I live in Vermont. New Hampshire is live free or die. Vermont is eat Ben & Jerry's. I mean, we're different states. In this case, this child was sent home on 20 occasions. The school said it was a behavioral intervention. First of all, what's a suspension? And we're moving into discipline now. What is a disciplinary suspension? Who here was a principal? Who was a vice principal? I like it. The principal of vice in your schools. What is a suspension?
Removing the child from the educational setting.
Due to inappropriate behavior? Removing the child from the educational setting due to inappropriate behavior. On 20 occasions, this child was sent home due to inappropriate behavior. Isn't that right? And what services did you provide this child while they were being removed home? None, or I usually hear homework. The school said this was a positive behavioral intervention. By the way, they even called it respite days. Now, as a teacher, there were days I needed respite. But as with any other intervention, it showed the more often that they kept being used with increasing frequency because this little bugger just wanted to go home. So it had actually the opposite impact of what the school claimed was a positive behavioral intervention. I think that was one of the saving graces in the, whoops, where is the Clark case? In the Clark case is that the use of data, the fact that this was part of a comprehensive plan. The school was articulating how the implementation of those positive behaviorals were starting to take hold and how the child's behavior increased throughout the use of the year, throughout the year, so the use of these rooms declined to almost nothing by the end of the year. Oh, for the days of spitballs or gum under the desk. And we are talking about some students who are posing some real difficulties in school. I would hope, as with any other behavioral plan, that we have people with some expertise in behavior to assist us in the development of that plan based on assessment data for that student. Questions on behavioral interventions or seclusion or restraint. I mean, we could talk again all day, but I highlighted some of the recent cases. We have one question or comment. Where's the mic? Can you raise your hand?
No, I don't.
It's you again. And if you're going to be talking about an athletic support, I missed that one completely.
So at the end of Ebony, you said, as you were trailing off, the parents would have agreed to the IEP and behavior support plan. But you didn't mean to say that, you meant to say they would have agreed to the IEP that had a behavior goal in it, but they don't necessarily have to agree with the behavior
They were
support
vehemently opposed to the use of these seclusion rooms and the seclusion observation room, or support room, what they called support room, or the support observation room. They were agreeable to the other portions of the behavior plan.
Do the parents need to agree with the behavior plan if it's considered curriculum to meet the goal written, the behavior goal in the IEP?
Yes, under Montana code, the behavior plan has to be part of the IEP. The parents have to agree to the IEP.
In person.
Would you have clarification from
Wait, hold on. I'm getting the code. First of all, we talked about one section of the code this morning where the parent has to give consent for the initial and the annual, right? The behavior plan has to be part of the IEP. Using aversives, but I'm gonna suggest that even absent aversives, we talked about what we're gonna do. So let's assume that the behavior plan is only gonna have issues such as timeout or a token economy or just positive things. I believe that the courts, and most recently yesterday, are saying that if behavior is shown to impact the child's learning, there's got to be behavioral goal and what we're going to do, not how we're going to do it. That's not that is not considered a behavioral plan. Now, I wanted to acknowledge the Eighth Circuit said a behavioral plan in the IDEA doesn't even need to be in writing. I think they are misunderstanding what a behavioral plan is. Now, if certain interventions are going to be used, such as seclusion and restraint, I am not a spokesperson for OPI, but I read your regulations as say...
The aversive treatment rule requires that the aversive treatment plan be a part of the IEP and requires a parental. But a behavior intervention plan, or a positive behavior intervention plan, as you said, isn't part of the IEP.
That's not what I said. I said earlier, if behavior is impeding the child's learning based on the evidence, there's got to be a goal addressing that behavior and what we're going to do. Timeout, anger management counseling, whatever. It doesn't have to say how we're going to implement each one of those, but that would be part of the IEP. A Q&A from the U.S. Department of Education in 2009 said, in the event that the team feels positive interventions, that behavior is impeding the child's learning, and positive behavioral intervention strategies and supports need to be provided, that needs to be part of the IEP. How we're going to carry that out, I called it a behavior implementation plan. Those details do not need to be part of the IEP. So I don't think I'm saying anything different now. Please help me if... I just did. Behavior intervention plan. Behavior goal and what we're going to do. Example, timeout, anger management, support room. That's not how we're going to do it. How we're going to do it, the day-to-day steps, to me is like a daily lesson plan in reading. Those details don't belong in an IEP.
Nor do they need a parent approval for how it's going to be.
So I think there's a distinction between, and it all boils down to how we are using the term behavior intervention plan. Now, Montana has a specific set of regulations, especially when aversives are going to be part of the plan. And it requires that even before we consider that be an IEP team decision, that we have evidence of 2 positive behavioral interventions that we have used, apparently with limited success if we're considering more intensive interventions. But as with any other part of the, I don't see from there on a real distinction other than in Montana, it says if we're going to use those aversives, the parent must be notified within 24 hours, but still, it would be part of the IEP for which the parent consents. If we have a behavior plan with only positive interventions, no aversives, to me it still is part of the IEP of what we're going to do, not how we're going to do it. Are we saying something different? I mean, help me, it's been a long day, so if yes, sir. Oh, wait, hold on.
what we may have here is a failure to communicate. Or hold the mic the right way.
You are a facilitator or mediator, aren't
you? Can tell right away. What I think the issue is, behavioral intervention plan sounds like a separate document. It sounds like something that's attached. What you're saying, what I think we have agreement on, it can be a behavioral goal.
It's part of the IEP. Like a transition plan is not a separate plan that's stapled to the IEP necessarily. The feds in their regulations unfortunately use the term BIP, Behavior Intervention Plan. I would like to say a behavioral intervention component, but that's not the term that they talk about. But it's not a separate document that's floating around somewhere. Just like a transition plan is embedded in the IEP, but it need not be a separate standalone plan. Does that make sense?
Just a quick clarification. So,
okay, excuse us.
And I think I'm kind of behind the 8 ball here because I think people are starting to get the rumbles like they're figuring it out. But so, like you're saying, sorry, you're saying that put in there that for Johnny we will have him have timeout or whatever when he acts out. Correct?
Well,
but then you're not going to say when he actually acts out, he'll have a 5-minute timeout or a 15-minute timeout or 15-minute timeout in one corner. You're not going to lay out that he's going to every single time the progressionary order and everything else, so that
that's the implementation phase.
So you just want to say we will be using timeouts with Johnny, as compared to laying it out 55 times in a row, so you don't accidentally miss line 53.
And the fact that we need to be able to, help me here, if those of you are behavioral specialists, we'll have to refine sometimes how we carry these out. And there's, for example, by the way, I think it is completely appropriate and necessary to have that discussion at the IEP meeting so the parent understands too that timeout doesn't mean suspension. In other words, so we talk so that I know what you're talking about. And I'll use my analogy and accept it or reject it. The same thing as reading. We have a reading goal. We have reading services for 30 minutes in the resource room. We don't have to say we're going to be using pages 15 through 32 of this text, and we're going to be using this. In other words, the day-to-day implementation are details where you and your staffs have to have some level of professional flexibility. Otherwise, think about some of these kids on behavior plans. We're going to have IEP meetings every Tuesday and Thursday. I am not aware of a lot. I am not aware of any court that ever said that kind of detail has to be part of an IEP in a behavioral component. So if I were king, and I would call it a behavioral component of an IEP. Because when we talk about transition plans, behavior plans, IEPs, I mean, it sounds like they're different documents floating around. They're really talking about components of the IEP.
Well, my question is, I want to talk loud enough here. Are you saying then if we're at a table and we have a child that has specific behavior issues, that we should take and address those within the behavior goals itself? Making that part of the plan instead of that separate document?
I would make it part of the IEP, yes. You'll have a reading goal, you may have a communication goal, you'll have a behavioral goal.
We're not used to doing some of that, though.
Now, as an attorney, you have a separate document that's called a behavior plan that is incorporated and stapled to the plan. I don't care. I don't care if you write it in the margins. As an attorney, it's what's in the four corners of the IEP. But I want you to understand, I am not saying the daily details of how we're implementing it has to be part of the IEP. That is, and some people say that's part of a behavioral intervention plan. If you're using the term in that context, then I would agree it need not be part of the IEP. I don't know what else to say. Moving on. And by the end of the day, I may need some behavioral interventions. You'll just implement that. Disciplinary changes of placement. How many of you have ever been part of a manifestation team? That's what I thought of. A manifestation determination has to take place if there's a disciplinary change of placement or placement in what's called an interim alternative educational setting. Now, none of this kind of detail is not in your outline, but if you turn to page 31, paragraph D, a case called Danny Kaye. Now, some of us will remember Danny Kaye in a different context. Who remembers Danny Kaye? Oh, thank God there's few of you. If a student on an IEP is going to be up for a disciplinary change of placement, which, number one, could be more than 10 consecutive school days of disciplinary removal. In other words, here we are on in mid-October, this kid engages in a major incident and is up for suspension for the remainder of the semester. That's more than 10 consecutive school days. By the way, that's pretty easy. That's kind of true-false. But you have to understand, too, we're in special law, so a day's not always a day. We don't want to make it easy. We have three kinds of days. We have school days, days in which kids attend school for instructional purposes. So you have an in-service day where the staff is there, but the kids are not. That's not a school day. You have, if it just says days, that's calendar days. And if you don't know what a calendar day is, we do have referral forms in the back of the room. And then we have business days, Monday through Friday, excluding state or federal holidays. Here we're talking about more than 10 consecutive school days. Or the more difficult is more than 10 cumulative school days of disciplinary removal in the same school year when school personnel determine that a pattern has existed. So 2 days here, 1 day there, half day here, because the Fed said you have to consider portions of the day. 1 day here, 5 days there. So first of all, let me just ask you rhetorically, especially if you're a disciplinarian in the school or you're working with the principals or assistant principals, how are you keeping track of the number of days a student on an IEP is suspended in a given school year? And by the way, it's going to depend. If you're a one-room schoolhouse, probably pretty easy, than if you're in a larger high school in Montana. But someone's got to keep track of it. And they don't say how, but I'm just asking you rhetorically. Before you exceed 11 in one school year, school personnel will need to determine whether the accumulated days of short-term removals amounts to a disciplinary change of placement, meaning a pattern exists. And the law says we have to look at such things such as, what does such as mean? Here's an example, but not the all-inclusive list. The length of each suspension, the cause of each suspension, the proximity of the suspensions to one another. And the law also says you could look at unique circumstances. Is this the son or daughter of the board chair? No, I'm only kidding. No, I'm not kidding, but that's another. In other words, here we are in mid-October. This kid has already accumulated more than 10 cumulative days of suspension. Well, that's going to start looking like and feeling like a change of placement, as opposed to a kid gets 2 days in September, 3 days in October, 1.5 days in November, no days in December, 2 days. In other words, a further drawn out. The kid is being suspended for different reasons. A little bit different than kid gets 10 and is up for another 10. So, I mean, by the way, this is a tough one. And I have challenged the people who wrote this back in 1999, and my good friend Jolita Reynolds, who wrote the regulations, has passed. But when I said, Jolita, I could come up with these hypotheticals and send your staff in the four corners of the room, and I bet you we'll get different answers. It's not, I wish I could say, if the kid got 10 within 8.2 weeks, I mean, no, it's not a formula. But if it's considered a change of placement, then a manifestation determination needs to take place before those additional days are imposed. However, regardless, services need to continue. Regardless of whether it's a manifestation or not, services have to continue. There is no such thing as a long-term suspension or expulsion of a kid on an IEP if you define long-term suspension or expulsion as a cessation of services for more than 10 days. Put it another way, a student on an IEP could never have services suspended for more than 10 school days in a given school year due to behavior, regardless of what the behavior is, regardless of whether it's a manifestation of their disability or not. Where those services are provided will be dependent on manifestation, but not whether. So sometimes I see so much angst building up for manifestation, because usually it's after a pretty significant event. I say take some of that energy and redirect it to determine how you're going to provide services, because regardless of the answer, you're going to come back to providing services. Danny Kaye. Well, first of all, the manifestation question. Is the conduct caused by, or did it have a direct and substantial relationship to the disability, or did it directly result from the school's failure to implement the IEP? This changed in the last reauthorization, because there used to be a presumption of manifestation, and now there is not. But there's more of a causation and a direct and substantial relationship, or did it result directly from the school's failure to implement the IEP? The kid had a behavioral component which you didn't implement. The kid went bonkers as a result and got in a fight, which is a little bit different. The speech pathologist was sick that day, so the kid didn't get speech. That's why the kid got in a fight after school. I mean, that's going to be kind of hard to show it directly related. When you get to manifestation, it's done by, you must notify the parents, and you better start planning now, because, like I said, services start no later than the 11th cumulative day of removal, regardless of what the decision will be. And by the way, since I have your attention, the services called for in the IDEA are services that both enable the student to make progress toward his or her goals, and services that allow continued involvement and progress in the general ed curriculum. So this kid with a speech-only IEP, you're still going to have to be looking at math and science and so forth. It's not just continued speech services. Now let's go to Hawaii. By the way, if I held a special ed law seminar in Hawaii, would you come? How about special ed law and Mai Tais? Were you able to get a PO through your board on that one? Yeah. Danny Kaye. Danny Kaye. This case is on page 31 and 32. In this case, the court, at first they said the kid used explosives in school. Here's what really happened. I happen to know the principal. Here's a kid who was 16 years old at the time, ADHD. He set off a cherry bomb in the boys' bathroom. It did damage to the boys' bathroom. People heard the cherry bomb go off. This kid was the only kid in the bathroom. The vice principal said, "Bubba, come with me." And Bubba confessed that he did it. He was told at the time, "Bubba, You're in deep doo-doo. And actually in Hawaii they call it caca. You're in deep caca. And you're up for suspension for 1 year. But before we suspend, the child was on an IEP, they called a manifestation determination. The manifestation determination meeting determined that it was not a manifestation of his disability. The parent has a legal right to challenge that determination in an expedited due process hearing. And I'll be talking to the hearing officers tomorrow about the process of an expedited hearing. The plaintiffs, first of all, would save the school ultimately prevailed in court. But one of the things that the school had for a manifestation meeting, and I would highly recommend, in fact, I had recommended to the Department of Education in Hawaii, and they had a worksheet for manifestation that laid out the elements. And they also gave the worksheet to the parent and the staff before the meeting so they could give some thought instead of being presented. So and the worksheet had blank, you had to fill out so that forced the team to consider every element. And that worksheet, I think, came back to show and document that the team gave proper consideration. First of all, the parents say the team was aware that the student took the blame for the incident in order to be paid by some of his friends. And they failed to analyze or consider whether his confession to the vice principal that he did it was related to his disability. For instance, his propensity for impulsivity. The court rejects this argument, which the parents repeat several times, as an improper attempt to resurrect the question of whether the student actually set off the firework. It is not the court's role to determine whether the student falsely confessed to the setting off of the firework, and neither was it the role of the hearing officer, nor was it the role of the manifestation determination team. Instead, the manifestation team was required by the IDEA to determine whether the actions leading to the student's potential suspension, as determined by the school's investigation, was a manifestation of an eligible disability or the school's failure to implement the IEP. The parents cite no authority, and this court is aware of none, to suggest that a manifestation team must review the merits of a school's finding as to how the school violated the student code of conduct. Such a requirement would essentially deputize manifestation determination teams and in turn administrative hearing officers and federal courts as appellate deans of students. This is inconsistent with the IDEA's congressional intent in streamlining the IDEA. Well, I'm not sure the Congress achieved their goal of streamlining the IDEA. But did you hear what the court said, basically? That the kid confessed. The team does not need to revisit whether the student actually engaged in that conduct because the school already determined that the student did based on the student's admission. Here, there was no question that his placement and IEP were appropriate. No question that they were actually being implemented. The team determined that there was a manifestation, that there was not a manifestation. By the way, they also argued that the vice principal who made the determination that the kid did it was a member of the manifestation team, prejudiced the team. He should not have been part of the manifestation meeting. The court said, that's silly. Well, the court is unpersuaded by the parents' argument that the vice principal should not have led the manifestation determination meeting because he was the one who investigated the incident. The court agrees with the school that it makes complete sense for that person to lead the meeting since he was the vice principal as well as a school official most familiar with the incident. The kid was then sent to an alternative learning center because you cannot suspend a kid for a year if you mean suspension as termination of services. By the way, I think that's really important for parents to understand that if we talk about suspension, if there's no manifestation, what the school can do is remove little Bubba's butt from his last placement and place it somewhere else for services. So where those services are provided could be impacted by manifestation. But there is no such thing as a one-year suspension. And by the way, the court said, and especially in small districts, this is important, that the only option of where that the team considers cannot be the home. By the way, it didn't say you can't consider the home. That can't be the only option you consider. You weren't paying attention, people. You weren't paying attention. Also, paragraph G, a brand new letter that the feds sent out on bus suspension. Let's see if I could. Well, I can't find it. I have too many pieces of paper. No, I was looking to be able to quote from. I know it well enough I could talk about it. In this letter, they said if bus transportation is listed as a related service, and this kid is suspended from the bus, and the parents drive him to school, you still have to consider that as a suspension. Don't look at me. This is on page 33, paragraph G. A bus suspension must be treated as any other disciplinary removal. If transportation is listed on the IEP, now, if the family voluntarily transport the student to and from school, does not change the analysis. However, the comments to the regulation says this: if a kid has transportation, by the way, don't do what one district administrator did after reading this. Staff, transportation will not be in anyone's IEP next year. Wait, by the way, she not only said it, she put it in a memo. I should say the soon-to-be former administrator. I mean, no, it's not only wrong, it was stupid. If transportation is listed as a related service in this child's IEP, and this kid is suspended from the bus, and the school offers no alternative way to get the kid to and from school. One alternative way, if the parents are agreeable, is for the parents to transport the student and you reimburse them mileage. You can't require them. This says if they just voluntarily do it, you didn't offer they didn't even talk about reimbursement, but the comments to the regs talk about if you offer reimbursement and the parents are agreeable, then you would not have to treat that as a suspension. This letter is getting lots of attention. Let me do this before I move back to least restrictive environment. Any other questions? Oh, two last cases on discipline. Rodriguez. Here was a kid on an IEP in a high school student. He was caught stealing beer. Fortunately, it was not from the faculty lounge. It was in the community. Apparently, this was not his first interaction with law enforcement. The juvenile judge said, Bart, you are going to juvenile correction facility. Now, parent, I will give you the option, if you place Bart, because this was like the culmination, this was not the first incident in the community. If you place your child in a treatment facility, I will allow you that as an option as opposed to a correctional facility. So as a parent, what are you going to do? Everything you can to keep your kid out of the corrections. So they placed the kid in the correction facility and then asked the school to pay for it. I mean, in the treatment facility, and asked the school to pay for it. They alleged that the school's IP was inappropriate because it did not include a behavioral component. The Ninth Circuit eventually held that the student's behavior in school was not perfect, but was not troublesome enough to have elevated the need for a behavioral component in the IEP, therefore upheld the IEP. And that not every child on an IEP, or every child on an IEP that occasionally gets into a behavioral issue, has to have a behavioral component. Lastly, the law says that the procedural disciplinary protections of the law apply even if kids are not disabled if there was reason to suspect that the kid had a disability prior to. Case out of Ohio called the Jackson versus Northwest School District. Here was a child, I believe initially in 3rd grade, was sent to a general ed intervention team. An intervention plan was developed. And it was probably focused mostly on behavioral issues. The interventions were implemented. The interventions were not working effectively. The team met again and made a referral to a mental health agency. The kid then got into a major incident at school and was suspended. The court said at the point where the general ed intervention team sought the assistance of a mental health agency, the red flag was raised to put the school on notice that the child may have a disability. Therefore, the disciplinary protections of the IDEA applied, even though at that point the child had never been identified as IEP eligible. Questions on discipline. Let me go back then. Anybody have a question on any of these? Yes. Yes.
I am going to jump back for a second. I'm going to jump back to the behavior plan and the IEP because there's still some concern here.
Please. No, I'll go there.
What I want to clarify is that what Art is saying is the same advice that OPI has been giving you. And this is what Mike tried to say with our failure to communicate. The IEP must contain behavioral goals and describe the services that will be provided. But what we would term the behavioral plan itself is a separate document from the IEP. That's the curriculum that you're going to use to address that behavioral goal. So I just want to be clear that what Art is saying is the same advice that we have been giving from OPI. It's just the terminology is what's goofing everybody up here. I just needed to clarify that.
Thank you for doing that. And I think, as you pointed out, the term plan is confusing, and sometimes for those of you who are behavioral specialists or psychologists, sometimes in your profession you use the term differently than the law contemplates it. And so I think that is all adding to. There's a case called Yates versus Washoe County out of Nevada, where the court upheld the IEP for not having a plan because it included intervention supports and strategies. To me, and I happen to know people involved in that case, it was the misuse of the term, it was the different use of the term behavior intervention plan by the parents in the district. They were using the terms to mean different things. So, no, thank you, Frank, for clarifying that. So, since we're all together on this little version of Kumbaya, no, I'm only kidding. Let's go back to least restrictive environment. Let's go back to least restrictive environment. So if you go back to page 22, LRE is pretty simple. to the maximum extent appropriate, kids with disabilities shall be educated with kids who are not disabled. The IEP shall explain the extent, if any, to which a child will not be involved with their peers who are not disabled. Explain. And it's like, drives me crazy. The least restrictive environment for the student is a special class because her needs cannot be met in a regular class. You didn't really explain, you restated the decision. A little bit more, what supplementary aids and services? By the way, there is no such thing as full inclusion under the law. When I'm asked to do a session on full inclusion, I refuse. I call full implementation of least restrictive environment. If you took the position that every child on an IEP, regardless of their needs to be placed full-time in a regular class environment, you would be in conflict with the law. Similarly, if you took the position that every child on an IEP needed a special class, you'd be in conflict of the law. The IDEA requires IEP teams in developing IEPs to look at the individual and unique needs of the child. It does say every time we revisit a child's IEP and we talk about placement, we have to ask, can this child be appropriately placed in a regular class, full-time, part-time, with supplementary aids and services? And only after the team says no do we move toward a more restrictive setting. So you have a child in a special class this year. When you are revising her IEP for next year and you get to placement, the question is not whether she should stay in the special class. The question is, can she appropriately be educated in a regular class? All of the day, part of the day? What kind of supplementary aids and services have you considered before you move down the continuum? That's not new. That's been in the law since 1975. Let's talk about a case from the Ninth Circuit called HB. Here was a kid who the parent was unhappy with and placed the child in a private placement and asked the hearing officer to award reimbursement. The school finally settled and said, okay, for this school year we will pay for that placement. So in planning the IEP for the following school year, before the IEP meeting, they actually hired a person to help transition the child back to the public school, and the person chairing the meeting basically said this: thank you everyone for being here at Bart Simpson's IEP meeting. The purpose of today's meeting is to make sure that Bart has a successful first day back in the public school this upcoming year. So we want to make sure that we have a comprehensive plan for Bart when he comes back to public school this year. We want the supports in place so on day one he's successful. The court said those kinds of statements, the fact that they already hired a person to help transition the student back, the school never gave any good faith consideration to the parents' desire to keep the kid in the private special ed school, was all evidence of predetermination, and therefore found that FAPE was denied because the parents were not given an opportunity to be meaningful participants. I would say probably the hottest issue in the last year or so is, well, let me talk about this case. Then I'll talk about the hottest issue. Case called DY versus Matsu. Matsu is a borough north of Anchorage. Wasilla? Somebody we know lives next to Wasilla High School, and I've seen Russia. I was on top of the high school. Now, I actually did an in-service at Wasilla High School. In this case, here was a family, and the school has had a history of due process regarding their child who's autistic. The child was about to enter middle school. The geographic zone, and there was 2 middle schools in the school district. The child was going to go to a middle school that was quite large. The parent wanted the child sent to the other middle school about 30 miles away in the district that was much smaller, feeling, especially since this child has autism and really is impacted by sounds and sensory stimulation, that a smaller, quieter environment would be much more conducive to a positive educational experience. The administrator at the IEP meeting would not allow the team to discuss whether the kid would go to the big middle school or the little middle school. And said that's an issue of location as opposed to placement. The parent got an independent evaluation stating that this child would be much better off at the smaller middle school. It goes to a hearing. The hearing officer held that by failing to allow the team to address it, FAPE was denied because the parent was not allowed meaningful benefit. The federal court in Alaska reversed and said the whole problem with this is that there's a difference between placement and location. Placement does not mean which school or which classroom the student will attend, but the type of program. In this case, there was no evidence. In fact, remember the independent evaluator testified the kid would be much better off at the smaller school, never said that the kid could not get benefit at the bigger school. The issue legally is not which is the better of the two. For me, the parent, that's the issue, but from a legal perspective, it isn't. The court said that the parent has to be involved in the placement decision. And I've been asked by parents around the country, where's the best place for special ed? And they want me to say the state of, and I firmly believe what I'm about to say is the best answer. The best place for a kid on an IEP, the best educational placement, is in a classroom with a good teacher and a building with a strong leader. By the way, that's true for kids who are not disabled. The assignment of personnel, which classroom this kid has, could be the most important decision as to whether this kid will be successful. But the courts, including the Ninth Circuit, said personnel assignments are not IEP team decisions. By the way, if the IEP team puts it in, it's a commitment. You've seen those teachers like Art Cernosia, who's cut and dry, and well, we don't have dittos anymore, or do you? I mean, but in other words, there's like drill work and whatever, and this kid's learning style is not compatible with my teaching style, as opposed to Mary in the next classroom in the same grade level, who understands that kids learn differently, and she does her best to engage in what I'll call differentiated instruction, recognizing that kids have different learning styles. And in some of your schools, it makes no difference because we're talking about the third grade. We are talking about the third grade, or probably the third and fourth grade combined. I mean, so in some of our smaller schools. But which teacher, which school, the courts have held is not a placement determination, but a determination of location. The DY case. Preschoolers. Probably the biggest issue that's come up in the last year has been on the issue of preschool. And to be honest with you, the U.S. Department of Education earlier this year, and if you look on page 24, paragraph F, issued this guidance letter earlier this year about preschoolers and LRE. It says nothing new. But people I've encountered said, oh my God, did you see this letter? Can you talk about this letter? This is simply a reminder of what the law has been. Let me just ask you, do any of you have universal programs for all and 3-4-year-olds in your district? I see it's around the country a smattering of hands. By the way, the hands are getting lower because of budget cuts, where some schools started it but couldn't maintain it because of cuts in budgets and whatever. So if you don't have, let me just ask you rhetorically, if I'm a parent of a child who's been newly identified as an IEP student who's 3 years old, what would be the continuum of placements you would have to discuss with me? The loss, before a child with a disability can be placed outside the regular ed environment, the group of persons making the placement decision must consider whether supplementary aids and services could be provided that would enable the child, including a preschool child with a disability, to be in the regular ed setting. The public agency responsible for providing a FAPE to a preschool child with a disability must make the full continuum of alternative placements, including instruction in regular classes, special schools, available. LRE applies to 3, 4, and 5-year-olds. On the other hand, you don't have to establish a regular ed program for your 3 and 4-year-olds. Most of you have kindergarten, I assume, at 5, or is it 6 here? 5. I found in one state it's 6, but most states it's 5. So you have a kindergarten program, but what do you do for your 3 and 4-year-olds? LEAs do not have a public preschool program that can provide all appropriate services must explore alternative methods to ensure that LRE requirements are met. These methods may include providing opportunities for participation of preschool program with disabilities in preschool programs operated by public agencies other than the LEA, such as Head Start or a community-based child care, enrolling preschool children with disabilities in private preschool programs for non-disabled preschool children, locating classes for preschool children with disabilities in regular elementary schools, or providing home-based services. The law does not permit to say we have a center-based program just for our preschoolers with disabilities, and that's what we have. The courts that have addressed this have struck this down. Now, there's a couple cases that I included on this. Probably the lead case recently is on page 25, paragraph G, called the LG case, where this was a child with autism that was placed in the school's special class program for preschoolers with autism. The parents wanted the child placed in an inclusive preschool setting. While this issue was festering, and I don't like the term, the school started a reverse inclusion component. What do they mean by that? They brought in one non-disabled preschooler to play with the other kids. The court said, based on this facts of this case, said that the least restrictive in the present case, the hearing officer's findings of fact were sufficient to determine that the school district reasonably concluded that a completely segregated environment for the student's IEP was the least restrictive environment. The student did not have the prerequisite skills for a less restrictive environment. She demonstrated inappropriate and stigmatizing behaviors, would wander aimlessly if not in a highly structured environment. The ALJ also concluded that the student would not have benefited from a less restrictive environment because she didn't even notice who her peers were, much less gain from modeling their appropriate behavior. The review of the video provided by the student's parents generally confirmed the interpretation of the school that the student is unable to engage with any of her peers, whether they're disabled or not. The addition of the reverse inclusion component to the program also demonstrates the school's efforts to provide the student at least with an opportunity to interact with a typically developing peer. These facts demonstrate that there was a proper conclusion that the special class program at this point in the child's life was a full-time separate classroom. I have to say the reverse inclusion component, bringing in one student, or if you look, it says in the memo, if you locate the a program, a public school program, oops, I didn't put up there, locate the public school program in a regular elementary school, but if there's no interaction, I wouldn't want to necessarily defend that. I would want to show at least some level of interaction with non-disabled kindergartners so that in terms of modeling behavior, acquisition of language, etc. This seems to be an emerging issue. It's been kind of boiling there. There was a big case out of Salt Lake City some years ago called the Nebo case. But let me ask you, how many of you don't even have a private preschool in your community? Oh, some of you. I would have thought even more in some of the rural parts of the state. So sometimes our geographics limit us. By the way, there's an old case from the Ninth Circuit that didn't deal with preschool, but it's called Pulaw versus Bishop. And this kid lived in a rural part of northern Arizona, and he was deaf. And he needed a full immersion program in communication, American Sign Language. The Ninth Circuit said the geographic location and population density will be relevant factors in determining whether the continuum requirements are met. How can you have a full immersion program for a child who's deaf in American Sign Language when there's no other child who's deaf in the community or within reasonable commuting range? So in some parts, so I would imagine in the more populated parts of your state, the expectations is that the community is going to be healthier than in the more remote parts of the state. And the Ninth Circuit has said that that is a legitimate factor to consider. In fact, the Pulaw case, they said the least restrictive environment was in the state school for the deaf, 275 miles away from the child's home. I bet you if that case came out in suburban Phoenix, the conclusion would have been different. Questions on LRE. Now, I'm going to allow, hold on, I'm going to allow for 15 minutes at the very end questions, any questions we haven't talked about. I did want to talk about bullying and the provision of FAPE, because I will tell you, I did a session at the Pacific Northwest Conference. I counted since the first of the year, January 1st, I have 43 court cases. So this is kind of a emerging issue. If you would turn to page 34. By the way, most every state that I've worked in has a state definition of harassment and bullying. Montana is one of those states that does not. I did get on the web page. There is a resource page on harassment and bullying. I checked with Mary to make sure I wasn't missing anything. There is no state definition of harassment and bullying. What's the legal distinction between harassment based on disability and bullying? Somebody?
Would harassment be evidence over time?
No. Harassment could be verbal, nonverbal, or physical behaviors that is motivated based on the student having a disability or perceived disability that has the effect or impact of creating a hostile educational environment. The feds in the year 2000 said it could be a denial of FAPE under the IDEA and 504 in the Americans with Disabilities Act. And I have a right to initiate a due process hearing. In other words, bullying is one student taking action against another student because of their disability. You retard, every time the kid gets up to go to maybe resource room, they're made fun of, and there's been a history of other kinds of actions. Whereas bullying, by the way, there is no federal law that defines bullying. There is a great website, however, that just went up this year by the U.S. Department of Health and Human Services. It's called stopbullying.gov. A lot of resources. Bullying is basically unwanted aggressive behavior where one student or a set of students takes action to intimidate or threaten another student, not because of their sex or race or gender or disability status, but it's more of a power issue, a perceived power imbalance. In this case, they're saying in order to constitute bullying from a legal perspective, it's got to be repeated over time. Making threats, spreading rumors. I will say the biggest issue now, cyberbullying, where kids and adults will say things on text and email that they would not say face-to-face. The biggest case on bullying and kids with disabilities is from New York now. It's called TK. Here's what happened. Here we have a child who's autistic. Actually, primarily autistic, multiply disabled. Discuss. Here it is. She's 12 years old at the time. We had a one-on-one paraprofessional. The parents said, our child is being bullied. These were by other special ed students. Drawing caricatures of her in a disparaging light. One student chased her and said, I'm going to squirt blood on you. It was really ketchup. If she touched anything, no one else would touch it. They would throw food at her. She got some phone calls and emails that were not inviting her over to play. In other words, pretty disparaging. The paraprofessional went to the teacher and said, these other kids, the teacher said, just you work with the student, that's your job. I'll take care of the class. Now, this was a motion for summary judgment, so everything that the parent alleged had to be assumed as true for the purposes of this case. The parent at the IEP meeting wanted to bring up the fact that their child did not want to come to school anymore because she was being bullied. The principal was at the meeting and said, this is not a proper issue. It is not listed under the IDEA or 504 as an issue. It is not proper for the IEP team. The parent then met with their daughter in the principal's office. The principal says, I'm going to ask you to leave now. This is what the court said. This is the only thing I know. I'm going to ask you to leave now. Got up, opened the door, and said, if you don't leave, I'm calling school security. I'm thinking as this comes in that I can't imagine the court welling up with tears for the school. The parent requested a due process hearing. The hearing officer found that the child did receive FAPE. It gets appealed to federal court. This federal court decision, now for those of us who are attorneys, this doesn't read like a normal court decision. This reads like a journal article. Bullying in America. What constitutes bullying? Cyberbullying. Distinguishing bullying from horseplay. How does bullying differ between boys and girls? Why do kids bully? Bullying in students with disabilities. The effects of the bullying and the effects on children. Bullying and the effects on the victim. Bullying and the effects on the bullier. Bullying and the effects on the bystander. I mean, this is a 30-page decision that cites journal. I mean, it's quite entertaining and readable, but it's not something I normally see in a court decision. It's more like a research paper. Then they get to the legal standard. And they talk about, and you will see on page 34, the court overturned the hearing officer and said the hearing officer and the state review officer, because in New York there's a two-tiered hearing system. In Montana there's one, it's most states now. But that neither the hearing officer or state review officer adequately considered whether bullying occurred, and if so, whether it impacted the child's ability to receive FAPE. So if you look at the very bottom of the page, they remanded the case back to the hearing officer. What does that mean? They sent it back for reconsideration, imposing this standard. When responding to bullying incidents, which may affect the opportunities of a special ed student to obtain appropriate education, a school must take prompt and appropriate action. It must investigate if the harassment is reported to have occurred. Stop. The court right now is starting to use harassment and bullying as synonyms. There are legal distinctions. Harassment based on disability is a violation of federal discrimination law. There is no federal, or in your case, state law on bullying. If harassment is found to have occurred, the school must take appropriate steps to prevent it in the future. This exists even if the misconduct is covered by the anti-bullying policy and regardless of whether the student has complained. It's not necessary to show that bullying prevented all opportunity for an appropriate education, but it's only likely to affect the opportunity for an appropriate education. And then lastly, bullying need not be a reaction to or related to a particular disability is a correct statement, because bullying, as distinct from harassment, bullying is not motivated by the student's disability. I will tell you, the courts are all over the place. Let me just say, among other things, if you look on page 37, paragraph F, a brand new case out of Maryland, where there was an allegation that their kid was bullied. The parents go right into federal court for monetary damages. The parents argue they don't have to go visit one of the due process hearing officers because bullying is not mentioned in the IDEA. The court said the bullying is not mentioned in the IDEA. But before you knock on the court's door, you have to do what? Exhaust your administrative remedies, and the issue in front of the hearing officer would be whether bullying or the set of behaviors that the student was subjected to interfered with their ability to receive a free, appropriate public education. So what does this mean? Most courts now are starting to send it back to due process hearing officers. And I just spoke to a group of hearing officers. About half of them have had hearings last year where at least one of the allegations was that the student was harassed or bullied, as one of many different allegations. But the term is being used so readily in the press and so forth on bullying and harassment. It's an important issue, but I would almost, well, you may not get a due process hearing request in Montana, but I think it's going to be a very real possibility that you will have a bullying or harassment claim. I'm just curious, as far as administrators or special educators, has anyone ever heard a parent complain that their child had been harassed or bullied? I mean, it's coming up over and over and over again. And among other things, that might have to be addressed in terms of the IEP, if it is true, regarding what? Kind of a safety component of the IEP. And I've seen some situations where the child, for example, in middle school, is allowed to leave a minute earlier to get to the class instead of being midstream. Or that the student has even special supervision assigned. There's one child who had an abnormality, a disability, both academic but a physical abnormality, had been teased to the point of tears in the boys' locker room. He was allowed to dress in a private place where he would not be subjected to. By the way, even if it doesn't amount to harassment and bullying, I hope we're sensitive to wanting kids to be safe and feel safe, and not wait till it elevates to that stage. Oh my. One last case, and then I'm going to open it up. By the way, I promised, I'm sorry, 2 last cases. Paragraph B on page 38. A case on seclusion and restraint from the 8th Circuit. In this case, the parent alleged that the use of physical restraint and seclusion violated their child's constitutional rights and they were seeking monetary damages. The school said, we are simply following the IEP as written. By the way, you should be aware that in the past there's been 3 bills introduced in Congress that would prohibit restraint and limit seclusion for students on IEPs. In this case, out of the 8th Circuit, the court held, we agree with the lower court that an authorized professional treatment of a disabled person within the state's care is reasonable if his or her actions are not a substantial departure from accepted professional judgment, practice, or standards. Here, the student's IEP addressed and authorized the use of restraints and seclusion. And we agree with the court that the IEP therefore set forth the standard of acceptable professional practice. Because the student's IEP addressed these methods, the teacher's use of these methods was not a substantial departure from accepted judgment, practice, or standards, and was not unreasonable. We would place educators in a very difficult position if we did not allow them to rely on a plan specifically approved by the student's parents and which they are statutorily required to follow. So ultimately, that plan saved the liability for the teacher. And by the way, there was no evidence in this case that there was an overuse or misuse or maliciousness on the use of restraint and seclusion, that it was used for punishment or anything. I wish that there's another case that's horrific that became the basis of that, but I don't have time to talk about that, and it's about 5 years old. The last case I want to talk about trumped the law according to Art. The court, this is the only case that came out on the issue. Question: I revoke my consent for my child's IEP services to continue. Is my child protected by Section 504? I wrote to the Office for Civil Rights right after the federal regulations came out that says a parent has a right to revoke consent for IDEA services, and those regulations say, we note that these regulations address only IDEA services and are not intended to address 504. I took the position that until the Office for Civil Rights or the courts clarify that if a student's parent revokes consent for IEP services, 504 also has a child fine provision, and that the child would be potentially protected by 504, and to notify the parent in the prior written notice ending all IEP services that if they would like to pursue a 504 plan for their student, which will look different than an IEP, let us know. The only case that I am aware of came out from Missouri, and you'll see that on the bottom of page 39, the top of page 40, the Lampkin case, where the court said, by rejecting IEP services, the parent has de facto rejected 504 services. And I'm not sure I'm really comfortable with that, because I'm not sure parents knowingly have done so. But that is the only case, and I don't know whether that's on appeal or not. So that's about all that there is. Hold tight. I am going to allow 10 minutes, actually 7 minutes, because I'm going to let you out 5 minutes early. 7 minutes for, and if people could just hold tight, for any other questions of issues we have not discussed. And if we don't have any questions, then I'd accept any questions of clarification of issues we have discussed other than behavioral intervention plans. Any other questions on topics we have not discussed? Yes.
I'm curious if the courts have addressed shortened school days, because I'm seeing a large increase in people's interest in shortening school days for students who have higher behavior needs and academic needs combined.
Have courts addressed shortened school days? Yes, to a limited extent. By the way, they've also they've also addressed extended school days for kids who need more. But shortened school days. Art would be comfortable if an IEP team addressed a shortened school day with the following caveats. Number one, that's based on the student's identified needs as identified in their assessment and not staff needs for respite. Two, there is an immediate goal of incrementally increasing the child to a full day. And three, that issue or that decision is made by the team and it's not based on the label or category of disability as no IEP team should do, which means number four, the parents are part of that decision making. But I would want an immediate goal of full school day. And most importantly, you have to articulate it as a team why the team is making that decision based on the student's needs, not based on the school's needs. Yes.
Real quick, any statements about compensatory ed? Any attempts to define or
yes.
guidelines?
Yes, compensatory education services. Let me cite two Ninth Circuit cases that are some of the lead cases in the country. The first case is called Student W versus Puyallup, Washington. You should have heard my first attempt at pronouncing Puyallup. It wasn't pretty. Well, I was just in Washington. I heard it was Puyallup. Here's what happened. This child was on an IEP. The parents moved out of the district, moved back in, different geographic zone. Moved out of the district, moved back in, different geographic zone. Moved out of the district, moved back in, different geographic zone. The third time they moved back in, no one happened to open the folder to see that this child was on an IEP. The parent calls the school and says, you know, normally this time of the year I get notified of my child's annual IEP meeting. School said, we'll get back to you. So someone went into the folder, so it was readily available, and the school blew it. This child did not get services for several months, I think like 4 months. The school calls the parent and apologizes and says, we blew it, our mistake, our fault. We owe your child services. So we offer your services, your child services next summer, not through extended school year, but additional services. The parents said no, thank you. The following summer, the offer of services again was made. No, thank you. The following year, the student graduates. Lawsuit for compensatory education. By the way, I talked to one of your hypothetical colleagues at break who's hypothetically dealing with an issue, and I see this, by the way, especially when a kid is about to graduate. The parents are very concerned, and if the student is 18 or older and not under guardianship, it's up to the 18-year-old to challenge. You know, I've seen some parents saying, we don't feel our child has the necessary skills. The young adult with a disability says, I've done my time, set me free. So first of all, you have to make sure that the person with legal standing, but in this case, the young man was persuaded by his parents to join the lawsuit. The Student W Ninth Circuit case says, if FAPE was deprived, and here it clearly was, because no services were provided under the IEP during the period of entitlement, we have to look at two factors: the behavior of the parties and the impact on the student. Here, the school twice offered additional services that the parent turned down. The student graduated with a regular ed diploma meeting all regular graduation standards, which the court said evidences at least some educational benefit. Comp ed denied. case out of another Ninth Circuit case called Park versus Anaheim. Now, these are old cases that are not in your outline, but I want to be responsive to the question here. Park versus Anaheim. Kid was denied FAPE in a certain area. The administrative law judge, the parents were seeking compensatory services, ordered additional training for certain staff members in the area where FAPE was denied so they could more effectively work with that student. Parents said, no, 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 you got this wrong. Compensatory education services means more services directly for our child. The court says, no, 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 no. Comp ed is an equitable remedy. In this case, the judge, our administrative law judge, articulated why additional training for those staff members and more effectively working for the student would directly relate to the deprivation of FAPE that they found. So it does not necessarily mean more services directly to the student. And I could go on, but there. Next. I'm going to take one more question or comment after this.
I just wanted to clarify, when you were talking about manifestation determination,
can you speak up for your friends?
When you said that it didn't matter whether it was found that it was a manifestation or was not a manifestation of the disability, you said the student would still receive services.
Correct.
And you're talking about the services in the IEP, not the entire education.
I'm talking about the whole shebang. Let me quote from the federal regulations, 300.530. One last reading from the federal regulations.
Art, do we need to stand?
No, just bow your head. 300.530, subsection D. When a child with a disability is removed from the child's placement pursuant to C or G, and that's long-term suspension or placement in an interim setting, the child must continue to receive educational services so as to enable the child to continue to participate in the general education curriculum, although maybe in another setting, and to progress toward meeting the child's goals set out in the IEP. So it's not just services that allows the kids, and I think I gave you the example of a kid with speech goals. This says services to allow them to participate in the general curriculum and to enable them to move toward their IEP goals. So it's not just special ed services. So yes, you did hear me incorrectly. And don't look at me. I gave you the citation. By the way, the feds and the courts have factored this in. No manifestation. This kid has been in a chemistry lab or maybe auto mechanics. You don't need to necessarily replicate or duplicate each class that the student was in, but you would have to look at curricular areas.
Essentially the same question, but Section 504, not in IDEA.
Big difference under 504. If a student is solely protected by 504 and they are going to be suspended on a long-term basis or expelled, and the determination is that there is no manifestation, then the school has no responsibility to provide any services to that student unless you provide services to non-disabled kids who are so suspended or expelled. If there is a manifestation, then you can't suspend or expel. But that's a major distinction between 504 and the IDEA. Just curious, how many schools here provide services to non-disabled kids who are suspended on a long-term basis or expelled? I see a couple hands. Then you would have to provide an opportunity for under 5, because 504 is a non-discrimination law. For the rest of you, that student would be entitled to nothing. So there. I hope today has been useful and practical. Mary is standing at that door, and Linda's sitting over here. You are not going to be allowed to leave unless you fill out those evaluation forms. But I would like to thank you for paying attention. Thank you. Thanks. I wanted to thank in particular the Montana Office of Public Instruction. Frank, in particular, you have great staff members. I know Mary and Linda have been a joy to work with. I hope today has been useful. I hope it affirms some things you know, because affirmation is important. I hope you learn some new things along the way. One last thought. Don't engage in what I call legal paralysis, where art says, oh my God, we could be sued here, you've got to do this, you can't do this. If you keep this child's educational interest as your guiding force, you're not going to go too far astray. So on behalf of my other state that I live in, mahalo. Thanks.